Hi everyone. Today I have an article. Well, it's actually from the American Bar Association. And it's from Sarah D. Irish. It's titled The American Bar Association Criminal Justice Section Report to the House Delegates Resolution. This is it urges all federal, state, local, territorial, and tribal government states to adopt forensic genetic genealogy (FGG) legislation similar to Maryland House Bill 240 2021. And we went over some of that yesterday. 2021. And we went over. And this one is for criminal procedure, regulating the use of FGG to identify suspect or victims in criminal cases, and that such legislation should require judicial supervision, which MPD did not do that. Provide access to the defense. They didn't do that. The only reason why the defense has access to that is because the judge ordered it. Initially, the state was not going to give them any of that information. They were being misleading in saying that IgG isn't discoverable. Number 3, follow the technical guidelines put forward by the FBI Department of Justice Interim Policy Forensic Genetic Genealogy DNA Analysis and Searching. And I believe that this is the document that is Ann Taylor included it in her declaration. And we went over that, I guess it was Saturday. We went over that and we went to the Maryland state government website, and we were reading a little bit about their IgG bill, because it's Maryland, Montana, and a third state that has laws. And so the American Bar Association and the Department of Justice, they both have used a lot of what Maryland has put into law for their guidelines. And a lot of it, as we were looking, is verbatim. They took sentences out and put it into their documents. Number 4, provide regulation and data privacy protections for direct-to-consumer database users. So MPD didn't do that either. So MPD didn't do 3 or 4. Because when we were reading the interim policy, they're supposed to keep all of that information regardless if it led to an arrest or not. They didn't do that. And Ann Taylor has already demonstrated that the FBI. Oh, hello. Hi, Jenny. Welcome. Oh, well, thank you for coming, even if you have to watch on mute. Oh, it's so good to see you. Welcome. Aw. Welcome, and I hope you had a good day today. And so the last time we were going over the Maryland state government website because they had the Maryland laws for IGG, and the American Bar Association and the Department of Justice have both taken exactly what Maryland has written, and they provide their own policies and guidelines based on that. I don't think it's word for word, but they have taken sentences verbatim over to include them in their documents. And let's see, give me just a second. And DNA. Okay. And then as we were going through, I just read 1 through 4 here, and MPD didn't do any of these when they were using IGG in the Brian Kohberger case. So I know the last time we were here was on Saturday, I think, and we were saying that it's a prima facie case. First time, I'm still a little confused if it's the first time they used IGG or the first time they've made IGG discoverable. And maybe at the time, I don't know why at the time Moscow Police Department wouldn't just follow these guidelines. Just follow them. It can't hurt anything to make sure that you followed them the best that you could. They say they did, but they did not. Because, well, the proof is that they didn't retain any of the records, and you're supposed to. So they did not follow it. They destroyed the records. The only time you're supposed to just destroy records is from a court order. And MPD did not receive that court order. So yeah. And then let's see. So we're going to scroll down to page 2. Introduction. The resolution supports state legislation relating to the use of forensic genetic genealogy, FGG, by law enforcement and urges all states to adopt FGG statutes based on the model legislation passed in Maryland, HB 240. Now, so this is the American Bar Association, and they're urging, they use a word like urging, all states to adopt these statutes. Now, if you haven't, I would think if you're a state and you haven't adopted these statutes yet, I would just follow them until it becomes formal. But apparently, MPD and the prosecutor, Bill Thompson, has just put it over on the FBI. They're like, well, the FBI does things that we don't have any control over. We don't see any of their work. But the issue with that is MPD is supposed to be the lead agency. So they're ultimately responsible for the way the investigation goes. And 2, I don't, in my opinion, that's not really an excuse because, this is the biggest case Idaho will have for years to come, and it has ever had. So even more important to make sure that the paperwork is as flawless as you can get it. Otherwise, I do think, well, they're going to have bigger problems than just the paperwork, but there you go. So, okay, so FGG involves law enforcement's use of forensic genetic information from direct-to-consumer genealogical databases such as GEDmatch and Family Tree DNA. Oh, I didn't give you a heart, Jenny. I'm going to give you some hearts. Okay. To identify suspects or victims in a criminal case. Now, in the Department of Justice policy, the criteria for using IgG is for an unsolved case, a threat to the public, an unsolved case, and unidentified victims. Well, we knew the victims were identified because Brett Payne identified Maddie and Kaylee immediately, is how it sounded in the PCA, whereas Xana and Ethan, he found out later through IDs and their personal belongings in their bedroom. But he did not need to do that with Kaylee and Maddie. So that's out. You can identify them. And it was still an ongoing case. It wasn't unsolved. And what was it? 7 weeks? 6 weeks? And so, I mean, the investigation had just opened. And the other day, we were also listening to Ortho. Christine Middleman, I think her name was. She's like the face of Ortho, and she was saying that they use IgG for the purposes of serial offenders and unidentified remains. So Brian is not a serial offender. So you've got things right there that would make IgG a no-go for the circumstances of the case as it was unfolding in real time. And then Anne did highlight that the FBI did violate their own terms of service and the direct-to-consumer privacy guidelines. So, according to Tracy Lee Dowswell, leader of the Forensic Genetic Genealogy Project, more than 620 cases have been solved using FGG, involving 290 perpetrators. Law enforcement's use of FGG continues to grow due to techniques' ability to generate investigative leads when traditional DNA profiling cannot. I'm interested to know, I think they need to further define that because there are physical limitations when DNA profiling cannot solve cases, especially when there's little genetic material or there's contamination. And in those instances, it's physically impossible to use DNA as a lead or to profile, which I do believe happened in this case. So there's another thing there that to consider. So now we're at ethical, legal, and social implications of forensic genetic genealogy. In most cases, FGG is used to find family members of potential perpetrator. Therefore, the individuals identified as a result of the search are not the punitive perpetrator, but a third party. The Maryland legislation lays out requirements of the use of FGG that will protect the autonomy and privacy of third parties. So if those individuals, the family members of a potential perpetrator are considered third party, what about the innocent DNA that's already existing in a crime scene? Are they considered third party? Because if so, MPT essentially used third-party DNA as their potential perpetrator. And I do believe that that's exactly why these policies are in place, so that you don't use these types of technologies. And, because DNA detection is so sensitive now, they can do it with just a few skin cells. What was it? 100 picograms or less. And that's the biggest worry, to identify DNA of an innocent individual that has nothing to do with the case. And I feel like that's what happened in this case. And so here, I haven't even, we've got, it's like, what, a page, and I'm stuck because they probably identified a third party and not the actual perpetrator. This is like one of the first paragraphs in this, like a page down paragraph. Oh, geez. Okay, so there are, where was I? Yeah, to protect the autonomy and privacy of third parties. Well, MPD didn't do that. There are 2 genealogical databases that currently permit law enforcement participation: Family Tree DNA and GEDmatch. These databases offer their consumers the option to opt out of law enforcement comparison. That's an interesting word that they use there, because the state uses that word in their motion to protect the IgG information, where the motion to protect uses similar language that isn't straightforward like it is in the probable cause affidavit. So when it says they compared this SNP to whatever they were doing, it's unclear whether they were just doing the act of comparing, because they didn't list any results. And a lot of times they will, well, I do think that's the prosecutor's fallacy, but let's keep a note on this word comparisons here, because I've noticed a connection there. Okay. So other direct-to-consumer FTG companies do not allow law enforcement to use their services to prevent the potential misuse of information from these databases. And so Maryland's legislation requires that forensic genealogy, DNA analysis, and search may only be conducted using direct-to-consumer or publicly available open data personal genomics database that provides an explicit notice to its service users and the public that law enforcement may use its service sites to investigate crimes or to identify human remains. Seeks acknowledgement and consent from its service users. So again, MPD didn't do any of this. It's like every time we get to like, okay, this is how the American Bar Association wants states to approach the IgG. Every time you can just put an X on it because MPD did not do this. For the purpose of this legislation comes from concerns that law enforcement will exploit the utility of FGG and begin to use it for all cases. Okay. I feel like this is what MPD did. They want to use it for all cases, including misdemeanors. However, the Maryland bill further provides that FTG may not be initiated with judicial authorization. The crime is the commission of or attempt to commit murder, rape, a felony sexual offense, or a criminal act involving circumstances presenting a substantial and ongoing threat to the public or national security. They tried to fit what they were doing into this, but that is just so narrow, and they tried to put a third party's DNA into this little box of public safety and national security. Well, public safety threat. An STR DNA profile has already been developed from the forensic sample, was entered into a statewide database system, and the national database system has failed to identify a known individual. And unless the crime being investigated presents an ongoing threat to public safety or national security concerns, reasonable investigative leads have been pursued and failed to identify the perpetrator. Oh, reasonable investigative leads have failed to identify. So even if at the time NPD did think it was reasonable, which so far it's been going against this policy, in my opinion, I don't think it led to a perpetrator. Because from the sounds of it, it sounds like the FBI did not complete the IgG, and the FBI did not compare any SNPs. They didn't compare the SNP from the knife sheath to the defendants. The FBI didn't compare any of the STRs. I don't know who identified Brian, because the Idaho State Lab, they had a partial. They sent it out to Ortham. Ortham made a partial tree, which is in a footnote in the state's motion to protect the IgG motion. And so if Ortham's making a partial tree, they didn't identify Brian. So this is all very concerning, because even if they perceived it to be reasonable, yeah, it failed to identify a perpetrator. The bill explicitly states the criteria needed for the initiation of FGG, which prevents law enforcement exploitation. Lastly, the genetic information used to conduct FGG is very sensitive. It can also be used to determine if an individual has a medical condition. And hence, sharing or selling that information could lead to serious repercussions to ensure that this does not occur. The bill provides that biological samples subjected to FGG DNA analysis, whether forensic sample or third-party reference samples, may not be used to determine the sample's donor's genetic disposition for disease or any other medical condition or psychological trait. The prosecutor shall retain and disclose any records or materials as required under the Maryland Constitution or United States Constitution and the rules of discovery as provided by Maryland rules, but may not otherwise use or share the records or materials. So, like, does this page have a date on it? Because even if Bill Thompson was like, this is prima facie, we don't have any of these guidelines here, he should have known that the American Bar Association is going to have guidelines on it. I mean, a responsible state's attorneys should know there are resources out there to help them go about these kinds of things. FGG, so the need for regulation. FGG has been reportedly utilized since 2015. However, there is little to no statewide legislation addressing the use of FGG by law enforcement. In January of 2019, Family Tree DNA revealed that it had been secretly working with the FBI to sequence and compare crime scene DNA to the genetic profiles in its database. At the time, Family Tree DNA did not have an opt-out option. Oh my gosh, Miss Pottage, hello and welcome. How are you? It's so good to see you. Welcome. Let's give you some hearts. Miss Pottage. So I'm reading the American Bar Association report to the House delegates. And the American Bar Association urges all federal, state, local, territorial, and tribal government states to adopt the forensic genealogy legislation similar to what the Maryland House bill. The Maryland House bill is what Stephen Mercer helped to put together. And Maryland and Montana, and one other state, I don't remember which it is, but they have laws and statutes in place on how to use IGG in court. And so down here, I was curious to see when this was written, because it says here that even if MPD did just say this was reasonable, which I have a whole list of reasons why it was unreasonable for them to pursue that, it still could have failed to identify the perpetrator. And from the sounds of the motion to protect the IGG from the state, it doesn't sound like they completed the IGG. The bill explicitly states the criteria needed for the initiation of FGG, which prevents law enforcement exploitation. Lastly, the genetic information used to conduct FGG is very sensitive and can be used to determine if an individual has a medical condition. Oh, I read that. Oh, I was down here by the need. And so, moreover, there has been instances in which law enforcement has violated the services and policies of the genetic genealogy databases, which Ann Taylor has demonstrated the FBI in Kohberger's case did. It was recently revealed that a company that provides FGG services used a privacy loophole in GenMatch's services to conduct comparisons on individuals who explicitly opted out. The use of FGG for criminal investigation must be regulated to prevent privacy and ethical violations that will ultimately lead to public distrust. And I do feel like that is one of the fundamental things here in the Kohberger case, is that there are a lot of us out here that don't think that Moscow Police Department had the grounds to use IGG, and it's coming to light that they don't have the evidence to support the allegations they have against Brian Kohberger. And so those ethical violations that will ultimately lead to public distrust, I think that that's growing because of this situation. And I know that there was like a rush to judgment, and they needed to arrest somebody, I guess. But that's not justice. That's not true justice, just to arrest any person, anybody. So the history, the Maryland bill was created under the leadership of Senator Charles Sydnor III and Delegate Emily Shetty. I don't know how to say her name. The process involved the participation of multiple stakeholders and was a bipartisan effort that included the Maryland State Police, the Office of the Public Defender, bioethicists, academics, Maryland State's Attorneys Association, and the Innocence Project. Very interesting. I didn't realize if they mentioned that at the motion to compel hearing for the IGG, where Stephen Mercer and Gabriela Vargas and Becca Barlow and Lika Larkin were. I don't know if I remember them saying anything about the Innocence Project, but that's very cool that this all came about with their input. The bill received near unanimous bipartisan support and was passed in April of 2021. All right. and enacted in May of 2021. So this information was out there over a year. But this is something that Bill Thompson could have referenced before he got into that IgG stuff. Ugh. So, acceptance in the scientific community, the Maryland legislation follows the technical guidelines put forward by the FBI, Departments of Justice Interim Policy, forensic genetic genealogy, DNA analysis, and searching, the forensic investigative genealogy, National Technology Validation and Implementation Collaborative. Oh, that's a mouthful. And a group composed of forensic scientists, crime lab directors, and genetic genealogists published their policies and procedure guidelines in 2023. Oh, okay, so that's when they published it. All right. Well, if the FBI was using this, they knew all about this. They helped develop it. Okay, in addition to acknowledging the Maryland FGG bill, most of the NTVICS recommendations can be found in that bill. We had that bill up yesterday. I'll give you a peek of it. This is it. This is the Maryland state government website, so that's it right there. And then conclusion, FGG has the potential to identify suspects and exonerate the innocent. However, if left unregulated, it could negatively impact privacy and civil liberties. There it is. Definitely violated Brian's civil liberties. The genetic information that is collected to use FGG is highly sensitive and can include highly private information as medical conditions. Maryland was a historic leader in protecting the rights of those that develop DNA profiles. Their bill balances public safety needs and privacy rights and civil liberties. The ABA encourages other governing bodies to follow Maryland's lead. And that was respectfully submitted by Tina Luagang. I don't know how to say her last name. So she's the chair, criminal justice section, and this came out August 2024. Oh, so this was like now. Okay. General information. Well, what this says to me is that more states are going to adopt this. This is just a matter of time. Not all of them, of course, because, some of them, like to do their own thing. But, there's always those bills that the majority of states that they accept it. This is definitely going to be one of those, in my opinion. Indicate which of the ABA's 4 goals the resolution seeks to advance. 1. Serve our members. 2. Improve our profession. 3. Eliminate bias and enhance diversity. 4. Advance the rule of law and provide explanation on how it accomplishes this. Resolution advances Goal 4, advance the rule of law by supporting more comprehensive regulation of the use of genetic databases by law enforcement. Yeah. Okay, so what existing association policies are relevant to this resolution and how would they be affected by its adoption? No prior resolutions deal directly with genetic databases or FGG. The resolution will have no direct impact on any prior resolutions. If this is a late report, what urgency exists which requires action at this meeting of the House. No. Status, if applicable, Maryland House Bill 240 was enacted in May 2024. Brief explanation regarding plans if implementation of the policy, if adopted by the House of Delegates. If other states propose similar bills, this resolution allows the ABA to lobby on its behalf. Disclosure of interest, none. Okay. So this is the Maryland one. And right here, number one in Maryland, you can't initiate FGG without judicial authorization, which is good. Yeah. So all individuals who are not the source of the STR DNA profile obtained from the forensic sample and whose DNA was collected through informed consent or covertly during the course of the FGGS shall receive notice of that destruction by certified delivery. Yeah. So there's supposed to be documentation by the court saying, okay, now you can destroy that information. And then there's another document created that says, yes, it has been destroyed. So MPD didn't even keep that. That's so weird. Like, you would think like if this case was such a slam dunk, you would think the FBI would keep all the documents it needs. But it didn't. So a person who violates this subsection is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 5 years or a fine not exceeding 5,000 or both. Is that pain? So when this is all done, I guess Brian would have to sue him civilly. And then a person who violates this, Payne could be facing guilty of a misdemeanor and imprisonment not exceeding 5 years. Well, I guess maybe not, since this wasn't enacted. But the FBI is surely familiar. They helped create this, so they should have known. Okay. Well, either way, there are options for civil litigation there. A prosecutor is in a criminal case that involves an FGGS investigation may file with the Appellate Court of Maryland an appeal from an interlocutory order by a court that excludes or suppresses evidence in the form of an STR profile obtained from FGGS. Oh, that's interesting. But that's another one of those things. As soon as the prosecutor files that, there's a record of it in the Maryland Appellate Court. So again, Maryland wants more eyes on how they do this FGG. I mean, the first step is you need court order or judicial authorization, and there will be oversight from judicial author from the court throughout. And I think there was something in here about a yearly, yeah, everything that was used during the year that had FGG, it goes through a yearly review, and there are 11 different bodies that look at that information. So, and I guess included in that would be all of the um, anything that gets into the appellate court of Maryland as well for appeal. And I think that's so interesting that there are 11 different bodies. I forget all their names right now. I do have that on my Twitter. Let me see if I can pull that up. Oh, here it is. Mm. Okay, so I found it. Let me see if I can pull it up now. Okay, yeah, here's my Twitter. It's the first time I got Twitter up here. The FBI used the loophole. That's a technicality. BK may be freed, but one of the G's will probably enact their stupid revenge. But what if the DNA was a DNA smear that can't be unmuddled? You mean like a DNA that was contaminated, or the other way around, that it's a clear DNA profile? Yeah, I'm sure that that loophole is definitely going to come back and cause problems for the FBI. And it will probably work in Brian's favor. And that's the thing. Even if Brian is cleared by the DNA, people are still going to be like, they're going to swear that up and down that it was him, when everything points to it not being. It's very weird. So, in Maryland, there are a lot of people in the IGG-FGG. So these are all the bodies. There's a panel comprising of judges, prosecutors, defense attorneys, public defenders, law enforcement officials, crime laboratory directors, bioethicists, racial justice experts, criminal justice researchers, civil and privacy rights organizations, and organizations representing families impacted by the criminal justice system. Okay. How do they know it's one profile or 3/3 of 3 profiles? Exactly. That is a very good point that you bring up, Miss Pottage. I mean, especially when they talk about this sheath as if it was pristine, but it's a party house. There's going to be transfer, environmental, trace DNA everywhere. Even if it was wiped down, it should have come from a mixed sample. So because they're saying it was a single source, that doesn't necessarily mean it came from a single source. So hopefully it's difficult because maybe they haven't there's not a lot of documentation, but hopefully Ian Taylor has documentation showing exactly what you're saying there, that it did come from a mixture. And well, actually, I take that back, because in Bickup Barlow's declaration, it does say it's an ambiguous partial profile, which means it's open to interpretation. And the example she gave was the Hernandez case, and it was a multiple people mixture. And in that mixture, you couldn't tell who was a major contributor, a minor contributor, and you had many different interpretations of whose DNA that actually was. And so between Bicca Barlow saying that, yes, that's an ambiguous partial profile, and then using that case that she worked on, that from a mixture, I think that indicates to me it did come from a mixture. And because it came from a mixture, that it's hard to tell when you have a mixture. And then when we were reading that NIST study, where NIST sent a mixture, like a DNA profile mixture of like 3, 4, and 5 mixed samples, and they sent them these mixes to labs all over the nation. And the results it varied even within the same lab. Different analysts will come to different conclusions. So they never really agree on what they're actually looking at. And so even though we do have these great these machines so that we can blow up, like a few skin cells, and then we have all of these statistical programs, those things may or may not be accurate. They say that they're accurate, but then once you get down to the interpretation, it's like the wild, wild west, like the gold standard and what DNA is represented as completely unravels because of exactly what you're saying here. It's a very good point. Heather 4! Hey, driving and listening for a few minutes. Welcome, Heather number 4. It is so good to see you too. Let's see. We'll put some hearts in there for you. There you go. Good to see you. Okay. So this was the last page of this document that I was reading on Twitter. I think it's the actual, I don't know if, yeah, this is the actual bill here. Very last page. I don't know. Hopefully you can see it. It says the outcome of each authorized search, including whether the search resulted in an arrest or a conviction for the target offense, a panel comprising of judges, prosecutors, defense attorneys, public defenders, law enforcement officials, crime laboratory directors, bioethicists, racial justice experts, criminal justice researchers, civil and privacy rights organizations, and organizations representing families impacted by the criminal justice system shall be convened to review the annual report each year and make policy recommendations. So that to me says they're going to have lots of groups get together. Oh, I see your hearts, Heather. That's so sweet. And yearly, they're going to go over these the cases that involve IGG, and they're going to make policy recommendations. And a lot of that is like making policy recommendations to health insurance. There are these groups that get together and they have these different metrics that they use to say, was this a good idea? How did that go? Can we improve this over here? And so there's these big, think groups that come together and they do look at this information and they do make policy recommendations, and then it just goes from there. I am very impressed with these things that Maryland is doing, that they have all of those groups that I just listed, and they're going to do it yearly. And I also learned today when I was reading the Maryland state government website to their bill for the IGG, at the very end, it says a prosecutor in a criminal case that involves FGG investigation may file with the Appellate Court of Maryland in an appeal in an interlocutory order by the court that excludes or suppresses evidence in the form of an STR DNA profile obtained from the FGGS. So that to me sounds like the prosecutor has decisions to make after whether they want to file for some things in the appellate court. I guess that excludes the suppressions that were, I don't know, in the original case. But either way, that's still documented. You'll still have a trail of the life cycle of this FGG and how it flows through the judicial system, which that might not be perfect right there, but Maryland does have those 13 bodies that are going to look over it yearly. They're going to look at the policy. They're going to see what works and what needs to be fixed. And that's always positive when you have that going on. And they're even saying in that bill that they will have open dialogue about this. And so that's even cool. And, Moscow Police Department does a lot of candles to this. Like sometimes I can't even say Moscow Police or MPD without laughing a little. It says, enacted under Article 2 of the Maryland Constitution, May 30th, 2021. So that's their IGG stuff. Maryland House Bill 240. Now, it's a part of Maryland's Constitution and dated May 30th, 2021. I keep saying 13 entities. I think it's actually 11. Either way. And so, on one of my posts here on Twitter, I in December of 23, I posted, could the work that MPD did with this IGG stand up to the scrutiny of these 11 entities? Would it survive the examination in the standard practice in Maryland, Montana, or the UK? So the UK, I remember reading about that now. So the UK has similar laws to Maryland. I think they're even stricter. And that the court is involved almost every step of the way, and it is monitored very closely, and you need to get all kinds of permissions, and it has to be an exception to the rule. You have to have a very good argument of why you would need to use it. So, and I think that's interesting. I think the UK has a better understanding of this IGG stuff. I think they might have they have a little bit more rights. I think that they are a little bit more, the people there are a little bit more involved in their civil liberties. So, and I was also reading, oh, I don't know where that article is now, but they have defense attorneys that are already set up for the kind of abuses that Payne has done in this case, where there are programs in place where if you feel that you have been targeted by a police officer, you have legal rights. And there are defense attorneys out there that will walk you through that entire process, and that is just a regular part of their system. And I thought that that was amazing because we have these young officers that seem to be like on a power trip. All of those very young men, you know, in Idaho is that can be a recipe for disaster. Yeah. So I wonder where that article was, but that was cool that the UK already has done all this. Yeah. Let me see. I should have some more stuff here. Oh, this might be cool. Sarah D. Irish sent me this, and the title it's chapter 13, Admissibility of DNA Evidence in Court. It looks like a law book. Let's see. Forensic DNA typing has existed since the late 1980s and has been admitted in court cases as evidence of identity since the 1980s. Some DNA evidence admissibility questions are now relatively uncontroversial, such as a quote-unquote match between robust single-source polymerase chain reaction short tandem repeat PCR-STR profiles, and others are still conscientious, such as results of low copy number testing and interpretations of complex mixtures by expert systems. This chapter offers a brief overview of the legal rules governing the admissibility of forensic DNA typing results, primarily in U.S. court cases. Any discussion? Oh, I have a Miss Pottage. This DNA stuff is like the Wild West. Yes, the rules are meaningless. Yeah. Did anyone follow the Zachariah Anderson case? The DNA evidence was not scientific, but he was found guilty. Police framed him, in my opinion. Wow. No, I haven't heard of that one. I have been just only Brian's case for a while, but that's very interesting that it was not scientific. I also think it's interesting that as the public, I think we are starting to see that these police officers are framing people. That's very interesting. Okay. So like when I'm like on this page here reading the book, I can't see chat. So I got to remember to come over and every now and then and look at the chat. Okay, so where were we? Any discussions of admissibility of DNA in court, it should be said, is really a discussion of several different questions of admissibility. Let me blow this up a little. Too big. Before introducing evidence of a DNA profile quote-unquote match at trial, for example, the proponent must show not only the DNA typing method is reliable, Octillion, it's not reliable, but also the method of interpreting the results and calculating the statistical significance of the results is reliable. Thus, In a case involving a complex DNA mixture in which the prosecution alleges a suspect is a likely contributor and seeks to introduce a likelihood ratio, that's exactly what Bill Thompson did, that likelihood ratio, reported by a probabilistic genotyping software like True Allele. The prosecution might be called upon in pretrial reliability hearing to establish the reliability of one, the PCR-STR method used to compare alleles among various potential contributors to a mixture. 2, the reliability of the expert system in estimating the number of contributors and whether a peak is a true allele or an artifact. And 3, the reliability of the statistical method the system uses to generate the likelihood ratio, along with the reliability of the likelihood ratio, LR for short, itself is an expression to the jury of the statistical significance of the results. It is also worth noting that even where forensic DNA typing results are admissible as evidentiary and constitutional matter, their meaning and probative value might be vigorously contested at trial by the opponent. The parties might disagree over whether a peak is a true allele or artifact, and that must be that dropping in and out for that low copy DNA. All right, I'm checking on chat here. Okay. No, didn't see anything. I'm going back now. It is also worth noting that where forensic DNA typing results are admissible might be vigorously contested at trial by the opponent. The parties might disagree on whether there's a peak is a true allele or artifact, and offering conflicting expert testimony on the matter. Whether a match, listening on my break. Oh, hi, Jenny. See, sometimes I have my phone up here too. Sometimes it's on my phone, but my phone didn't catch all of the messages in the StreamYard app. It's very weird. Okay, whether a match is statistic is grossly overstated. We know it's grossly overstated and offer conflicting expert testimony on the matter. The relevant population of the potential contributors to a mixture. That's it. The first example, the first example that this law textbook offers is like the exact issue, or one of them, which would be the relevant population of potential contributors to a mixture. The next example is it the prevalence of phenomena like DNA transfer, which might offer an alternative innocent explanation for the presence of a person's DNA at a crime scene. An opponent might also question the qualifications or conclusions of a DNA expert, even if the expert succeeds in testifying. In short, the admissibility of DNA, that is, whether a judge or jury determining the facts of the case is even allowed to hear the rules of forensic DNA typing, is only the first of many questions related to how the legal system treats DNA evidence in court. The basic legal rules governing admissibility of DNA evidence. To be admissible in a civil or criminal trial in the United States, forensic DNA typing results must comply with the jurisdiction's rules of evidence. Each state, as well as the federal system, has its own rules of evidence, as well as provisions of the U.S. Constitution that give certain trial rights to those accused of a crime. This section focuses on the rules of admissibility of DNA evidence applicable at trial. Although not all court cases involving DNA go to trial, The results related to admissibility of evidence at trial loom large over settlement or plea negotiations, which are conducted in the shadow of a trial. And while DNA typing results might also be offered in legal proceedings beyond trial, such as sentencing proceedings, the rules governing admissibility of evidence at a sentencing are generally both simple and permissive. For example, the U.S. sentencing guidelines state that sentencing courts may consider relevant information without regard to its admissibility at trial, provided that the information has sufficient indicia of indicata. I don't know that word, of reliability. Okay. Reliability requirements for expert testimony. Ah. So Jenny's heard of the Zacharias Sitchin case. Okay. The first set of legal rules governing the admissibility of DNA relate to the requirement under statutory or common law rules of evidence, the expert testimony based on scientific methods be reliable. Nearly all DNA typing results offered to prove identity are presented through one or more expert witnesses, laboratory technicians, DNA analysts, statisticians, population geneticists, and the like. As a result, the admissibility of DNA will turn in part on the rules of evidence governing expert witness testimony in particular. Nearly every state, as well as the federal system, requires the expert testimony be based on reliable methodology. Some courts follow the so-called Frye standard. Frye is spelled Frye, the Frye standard. Delegate the question of reliability of DNA to the scientific community, allowing the admission of expert testimony based on DNA typing and interpretation methods so long as the methods are generally accepted within the relevant scientific community. Before the 1920s, scientific evidence was treated like most other evidence, subject only to the usual requirements of relevance, witness competence, and the like. But in 1923, the D.C. Circuit Court of Appeals in Frye v. United States held that a criminal defendant accused of murder, James Frye, could not offer the expert testimony of Dr. William Moulton Marston, who later create the character Wonder Woman. What is going on here? James Frye, we know a few of those. He couldn't offer the creator of Wonder Woman that Mr. Frye had taken and passed a polygraph examination. According to the Frye court, a novel scientific methodology like the polygraph should not be admitted unless it is sufficiently established as a method to have gained general acceptance among the authorities in the field. Because the polygraph had not yet gained such standing and scientific recognition, it was properly excluded by the trial court. The Frye General Acceptance Standard was highly influential and ultimately became the dominant standard in U.S. courts for admissibility. The expert testimony based on such methods. Okay, so the Frye General Acceptance Standard is a standard used to make sure that the science that is relied upon is generally accepted by the scientific community. And as we know, I don't think the polygraph is not admissible in court. It's never gotten there. Not until 1993, the U.S. Supreme Court's decision in Dalbert, I believe that is another standard, v. Merrill, Dow Pharmaceuticals, would the Fry's test dominance be challenged? In Daubert, the court held that the Federal Rule of Evidence governing admissibility of expert testimony, Rule 702, did not require an expert's method be generally accepted. The rule's language required only that the expert's scientific or other technical or specialized knowledge be helpful to the jury, which in turn required only a method, if purportedly scientific, be scientifically valid. Daubert. And like all preliminary questions related to admissibility of evidence, the scientific validity of an expert scientific method must be determined by the trial judge, not by the scientific community. Oh, that's good to know. All right. So the validity of an expert scientific method must be determined by the trial judge, not by the scientific community. Okay. Thus, the court reasoned expert testimony is admissible so long as the expert is qualified in her method. If scientific is deemed by the trial judge in determining scientific validity, the Daubert court relied heavily on Karl Popper's view of the scientific method. Influenced by Popper's preoccupation with the concept of falsifiability, the Daubert court set forth the following non-exhaustive list of factors to be considered by a judge in determining reliability of an expert method. 1. Whether the method can be and has been tested, whether the method has been subjected to peer review and publication. Number 3, the method's known or potential rate of error. 4, the existence and maintenance of standards controlling the technique's operation. And 5, whether the method is generally accepted in the relevant scientific community. In 2 subsequent decisions, the Supreme Court held that Daubert reliability tests applies not only to the method of an expert, but relies not only on the method an expert uses, but also the expert's application of the method. And that Daubert applies not only to scientific methods, but to all expert testimony, including non-scientific technical fields like tire tread analysis. Together, Daubert, Joyner, and Camo tire are typically called the Daubert trilogy. The language of the Federal Rule of Evidence 702 has been amended to reflect the trilogy's holdings and now requires both that the testimony is the product of reliable principles and methods, and that the expert has reliably applied the principles and methods to the facts of the case. Courts applying Daubert to scientific methods continue to apply the non-exhaustive Daubert factors: testability, peer review, existence and extent of error rate, existence of standards to govern the method, and general acceptance in the scientific community set forth by Daubert itself. Today, most states and federal systems have shifted to the Daubert standard, either through court decisions or through passage of a statute or rule, similar to Federal Rule of Evidence 702. Still, a significant minority of states, including New York and California, continue to adhere to the Fry in determining admissibility of novel scientific evidence such as DNA. Thus, in relying on precedent related to admissibility of a particular DNA method, litigants should be aware of which standard Fryer-Daubert governed the presidential decision and which standard governs the litigant's jurisdiction. The evidentiary rule against hearsay and the constitutional right of confrontation. Let me just check on the chat here. See what you are doing. Miss Potts, welcome. There's Miss Potts in the house. Oh, hello. Yes. This is a new channel. We are just finding our people, and we enjoy reading about DNA. And anybody is welcome to send me your DNA articles, and we'll go over them. And welcome, Miss Potts. So good to see you. Okay, Miss Pottage has a comment here. Zachariah Anderson has supporters, but it's not gaining traction like Karen Reed or BK. Sadly, his car wasn't seen en route to the murder. The DNA shouldn't have been admissible, but he didn't have Ann Taylor. Yeah. That is what it sounds like. Ann Taylor apparently is a gem. Oh, Miss Potts. So good to see you too. Yeah, we're going over IgG today, and now we're reading about the admissibility. Oh, can I do that? All right, let's see if that works. I just made my screen full screen, and it's not hiding chat, so I don't know what that means. The evidentiary rule against hearsay and constitutional right of confrontation. The second set of rules that might preclude admission of DNA typing results in the rule against hearsay and its corresponding constitutional rule, the Confrontation Clause of the Sixth Amendment to the U.S. Constitution. For better or worse, the Anglo-American system prefers that the claims of human witnesses, if offered for their truth, be made live in court, subject to I just lost my place here. Made live in court, subject to the oath, physical confrontation, and cross-examination. Thus, the federal rules of evidence exclude hearsay, an out-of-court statement offered for the truth of the matter asserted in the statement. So that reminds me, there are lots of out-of-court statements, as we know in the Brian Kohberger case. So a lot of that, it's just not going to make it into court. You know, none of that ridiculous things about the shower curtain or the Jason outfit. none of that is admissible. Well, that we know of now, but it does sound pretty ridiculous. And they only harped a lot on the Jason outfit really close to Halloween, and then they dropped it. Very weird. All right. An out-of-court statement offered for the truth of the matter asserted in statement as presumptively inadmissible. All 50 states have an analogous rule. Hearsay is thus inadmissible unless the proponent lays a foundation for admissibility under the applicable exception to the rule against hearsay, such as for business records. Statements against penal interest or dying declarations, even if a hearsay statement is admissible as evidentiary, so it's a dollar versus fry method. Yeah, it is. And I'm not sure what state, what Idaho State, what they use, which method is theirs. But yeah, for the DNA admissibility, statistical analysis, lab technicians, and it must satisfy the Daubert or Fry standard. Okay, what do we have here? Even if a hearsay statement is admissible as an evidentiary matter under an exception, its admission in a criminal case against the accused might still violate the Confrontation Clause if it is the testimonial hearsay of a non-testifying declarant. Hearsay is generally testimonial if it is sufficiently solemn statement that is either factually accusatory or created with the help of government officers. Okay. Such as a station house police confession of a defendant's alleged accomplice, or formal affidavit of a forensic chemist about the presence of a drug in a tested substance. In the context of DNA, these two rules arise most often when a testifying DNA expert determines a match or calculates a match statistic based in part on hearsay report of another DNA expert who does not testify at trial. Okay. Oh, 1 second. Okay, so I don't know how much longer we'll be going tonight, but let me see how far down the page we got here. Hearsay is generally testimonial if it is sufficiently solemn statement that is either factually accusatory. I read that. Okay, so now we're down here. We're on page number 4. Oh, let's read. Maybe we can read the single source PCR STR testing results and random match probabilities. Yeah, we'll read to like the top of this page, 297. All right, so in the context of DNA, these two rules arise most often when a testifying DNA expert determines a match or calculates. Just want to make sure that I am. All right, I'm not muted. Okay. A match or calculates a match statistic based in part on the hearsay report of another DNA expert who does not testify at trial. The Fourth Amendment to the Constitution also gives rise to the potential admissibility challenges to DNA evidence in court when offered in a criminal case against the accused. The Fourth Amendment protects against unreasonable search and seizures and prohibits the issuance of a search warrant or arrest warrant unless supported by probable cause. Ooh, 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 Brett might have a problem with that one. Okay. Police therefore apply a search warrant to obtain non-consensual DNA sample from a criminal suspect only if they have probable cause to believe the DNA will show that the suspect has committed the crime. How about that? That makes me think about the IGG, because now I think it's come to some of our attention that it may not have been completed. So if the IGG wasn't actually completed and the FBI did not actually identify Brian Kohberger, this is going to be a big issue right here. Police may therefore apply for a search warrant to obtain non-consensual DNA sample from a criminal suspect only if they have probable cause to believe the DNA will show that the suspect has committed a crime. Police can also obtain DNA from a suspect by consent without violating the Fourth Amendment. To the extent forced DNA sampling, in the absence of any individualized suspicion to believe the suspect is engaged in a crime, is unconstitutional. Any DNA test results stemming from such a Fourth Amendment violation may be inadmissible under the exclusionary rule as the fruit of a constitutional violation. As discussed further later in the chapter, the primary context in which criminal defendants have argued that evidence of a DNA match violates the Fourth Amendment in its database cold hit cases. Isn't that interesting? Was it Bickup Barlow or Leah Larkin? One of them talked about these cold hit cases. It was Bickup Barlow. In her declaration, she talked about these cold hit cases. Interesting. We'll have to go over that one again too. So, let's see. The status of reliability-based admissibility. Challenges to DNA evidence. This section explores the status of reliability challenges to various forms of DNA evidence, setting forth both areas of senses in which the reliability of DNA typing results will not only likely be disputed, and areas of controversy in which reliability of DNA typing results or statistical methods is more contentious. Single source PCA STR testing results and random match probabilities. This is what's talked about in the state's motion to protect the IGG. Some forms of DNA evidence are now universally accepted as evidence of identity in U.S. courts as a matter of reliability. The original forms of forensic DNA testing and interpretation used in the 1980s and early 1990s were subject to much criticism during the DNA wars. DNA wars, quote unquote, okay. The history of which has been aptly told by others, but these earlier techniques have been replaced in forensic DNA analysis by PCR-based STR discrete allele typing. Courts now universally accept as generally reliable both the PCR process for amplification of DNA and the STR-based system of identifying and comparing alleles. The most common PCR STR based kits used in forensic analysis is criminal cases in the United States are those manufactured by Applied Biosystems. Applied Biosystems. This is another name for one of those platforms that does next generation sequencing that we read about. I think it was Saturday or the time before, that some of these companies that have these platforms to sequence DNA, and Ortham in particular has the Illumina platform. And so the Applied Biosystems, I guess, is a competitor of that. And they have all different types of different lines, machines that, more powerful, not as powerful. They do this, they do that. So anyway, I recognize this name, Applied Biosystems. Such as profiler, co-filer, testing 13-core STR loci, including a melanogin or sex identifier, testing 16 loci, including melanogin, and most recently global filler, testing 24 loci. And Promagia's Power Flex Kits. I recognize this name too. They have a website that has good information about low copy DNA on it. Promega's? Promega has good information about low copy DNA. Okay, so these are the primary kits accepted by the Federal Bureau of Investigation, FBI, for uploading to the Combined DNA Index System, CODIS, for comparison purposes. All new reference samples taken by convicted or arrested persons for upload to CODIS must contain 20-core CODIS loci and thus must be tested using the most recent, most highly discriminating kits. All evidence from crime scenes or missing person inquiries must be at least tested for core CODIS loci through results at 20 loci are not necessarily for comparison purposes. Now, I read an FBI PowerPoint presentation where they have medium stringent, like strict stringent types of searches. So what they'll do is if they have like a partial profile, they'll take the strictness away for when you put in a profile, and it'll spit results back to you if there's any matches. But when you push the stringent down to medium, you're going to get a lot more matches back because of that partial. A partial matches much more people than a full profile, which I do believe they found a partial STR profile in this Brian Koberger case. So either there were no hits at all, or it was a partial and there were many hits. Okay, so in addition to the use of RMP, that's a random, that was the random something, the random match, there you go, random match probabilities. In addition to the use of random match probabilities to express the statistical significance of a match between two PCR, STR, single source, non-mixture profiles has always been universally accepted in U.S. courts. In general, evidence of a DNA match is inadmissible without a corresponding match statistic expressing the statistical significance of the match to the fact finder. So that's going to be interesting. I still want to know what expert is going to get on that stand and defend that octillion number. And is that even something the defense can replicate? Just like, how did you get to the octillion? So that would be interesting. In the words of one court, without the probability assessment, the jury does not know what to make of the fact that DNA patterns match. The jury does not know whether the patterns are as common as pictures with two eyes or as unique as the Mona Lisa. The random match probability is the product of probabilities of a person having each of the alleles represented in a single source, PCR-STR profile. While the random match probability has been the subject of some academic debate because its accuracy because of its accuracy rests on the assumption of statistical independence among the STR loci and minimal population substructure. This is going to be the issue for that octillion statistic because it's the random match probability as well. And minimal population substructure. Courts have universally accepted 2 single-source samples under both Fry and Dauber. Only where random match probability has been mistaken by a prosecutor as the chance of the defendant's innocence is the prosecutor's fallacy. This is exactly what Becca Barlow was talking about in her declaration. This is exactly what Bill Thompson did. Bill Thompson, he used the prosecutor's fallacy. Let's read about what that is. And then I got to go here. So we'll go on for like another 5 minutes. So as only where the random match probability has been mistaken by the prosecutor as the chance of the defendant's innocence, the prosecutor's fallacy or the fallacy of the transposed conditional, have courts commented on its potential for undue prejudice. Moreover, while expert witness assertions of source attribution based on random match probability have been the subject of some defense challenges, courts generally allow DNA experts to testify to their opinion based on exceedingly small random match probability that the DNA profiles have a common source. Common source does not sound as accurate as other vocabulary that we have heard about matching. For example, FBI analysis commonly testify to source attribution above any random match probability threshold of 1 in 30 billion. We've got what? 1 in octillion? Oh man. So I believe the prosecutor's fallacy is when you cite the test itself. And in addition to that, the random match probability is mistaken by the prosecution as the chance of the defense innocence. So that he's attributing guilt by this octillion number that we don't even know if it's scientifically sound yet. Which I think will be very interesting. So let's go. Let me see what you guys are doing in chat before we wind down here. Becca's here's Miss Potts. Becca declaration is where she talks about the DNA sample being partial and ambiguous. Absolutely right. Right. Yeah, and nobody wants to accept the fact that yes, it is partial and ambiguous, and especially and I think that's another reason why Orthan was only able to do a partial tree and the IgG may not have been completed. They don't have enough genetic material to make the conclusions that they are doing, but that is my opinion only. But yeah, it is partial and ambiguous. And people get so upset when I say that. You should see my Twitter page, Miss Potts. It's not as bad now. I know we all got it a lot in the beginning when we were on Twitter. Just bad people bash us, and we just kind of were politely standing our ground, and they've gotten less and less. I used to call them out for what they were. They were damage control bots or socks. Here's Miss Pottage. It's all about the DNA now. Someone's got to remind the parties of the interim policy because in this case, it was only used to wipe a scientist's snotty nose. Absolutely. Right. Bill Thompson says he used it, but he didn't. He didn't save any information. That's in direct violation of the policy. You're supposed to keep it whether it's a lead or an arrest. Miss Potts, you're amazing for going over all this. Oh, I am so happy to see you here, Miss Potts. Thank you for coming over today. We will do this again soon. I have put out a few videos where I've used editing, and that is a lot of work. It takes me forever. Where these lives are easy. I can just get on and I can talk to you all in the chat, and we can go over these textbooks, like these law books like we were doing. Maybe we can finish this one another day. So we got all the way up to YSTR and mitochondrial DNA. So, yeah, so if anybody's wondering, I will put this link in the comments. The book is called Admissibility of DNA Evidence in Court. And it's from the lawberkeley.edu. So, thank you all for coming today, and I will see you next time. Bye.